Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas, this honorable court.
Please be seated. Good morning. Welcome to the Supreme Court of Texas. We're going to hear argument in 3 cases this morning. The first case is number 240834, Carden versus Minton, Bassett, Flores, and Carsey from Travis County in the Third Court of Appeals. The second case is number 240879, In Re La Puerta from Harris County in the First Court of Appeals. And the third case is 241049, Diamond Hydraulics versus GAC Equipment from Williamson County in the Third Court of Appeals. The court has allotted 20 minutes for each side in each of the cases. We'll take a short break between the arguments, which can be viewed online and will be available on the court's website later today. We're ready for argument in case number 240834, Carden versus Minton, Bassett, Flores, and Carsey.
May it please the court, Mr. West will present argument for the petitioners. Petitioners have reserved 5 minutes for rebuttal.
May it please the court, I'm Gaines West. I represent the petitioners in this matter. And this is a really, I think, quite a simple case. The Third Court of Appeals didn't have the advantage, nor the trial court, have the advantage of your opinion that Chief Justice Blacklock authored just 9 months ago in Pitts v. Rivas. And in order to frame up the issues, to make this a simple review, there's 3 short statements in that case that I think are really important to view. One is on page 524, at 68, Texas Supreme Court Journal of 524. It says, if, however, the gravamen of the claim extends beyond professional negligence and the plaintiff raises a genuine fact issue on the additional elements of such a claim, then the claim will survive summary judgment. Further, on page 524, you write, Justice Blacklock, importantly, the anti-fracturing rule does not categorically bar a client from pursuing multiple causes of action against a professional, including claims for fraud or breach of fiduciary duty. Instead, the rule prohibits plaintiffs from attaching these labels and others like them to the allegations when the gravamen of the allegations is that the defendant failed to exercise the requisite degree of care or skill in the provision of professional services.
Let me just ask you something that sort of has
Yes,
to do
Justice
with that.
Flamerman.
So I believe that this person was told that some of the money was going to be used to hire an investigator. I mean, were they told that a certain, $10,000 or I don't know, a certain amount was going to be used for an investigator?
Yes, ma'am. Part of our claims, of course, are intentional torts, and you can't take intentional torts and turn them into negligence claims. And the point of the Pitts v. Rivas case is that
But that's not my question. My question is, was there a specific sum that was aimed specifically for that? Rather than just, I have a duty as an attorney and I need to do this and this and this and this and this. Was it, I need to hire an investigator, give me blank amount of money so I can go do that, and then that wasn't done?
the representation was $10,000, but we have not to this day gotten the breakdown of the $300,000 that my client provided for the trial of this matter. So the fact is, yes, there were specific amounts.
There was also expert representations that experts would be hired. Right?
That's correct, and they weren't.
They were not.
They were not.
That's your allegation. We're
That's
here on
right. That's our
91A,
allegation.
so
Again,
we have to take as true whatever's alleged.
Yeah, it's a 91A. This is a 91A review, and the point of the Pitts v. Rivas review is that was a summary judgment case. All of the cases we're looking at here, save and except one, are either directed verdict cases at trial or they're summary judgment cases where there was an opportunity to not only look at the allegations, but also the evidence that was presented leading up to a causation or approximate causation finding.
What is your summation about why this is more than just your ordinary malpractice claim?
Well, it's because in our pleadings, which I can detail for you in the record, but the clerk's record 333, 347 contain all of our pleadings that plead breach of contract, fiduciary duty, fraud.
Well, no, I understand that.
Yes.
I just mean, we're very familiar with all that. I'm just talking about in some, those also kind of sound like, legal malpractice claims.
No, ma'am, it's not. This is not legal malpractice. These are intentional torts. And as I said, you can't take Rule 91A to collapse it into a negligence claim because these are separate. And that was the point of all of what Chief Justice Blacklock wrote about for this court 9 months ago. And you know, the Third Court of Appeals didn't have that opinion. The trial court didn't have that opinion to help them in this analysis. And the analysis that we have here is specific to the fact that all we've done is plead. All we have done, and all we have are notice pleading requirements in the state of Texas. This is not a 12B6 motion. We don't have Iqbal and Twombly over on the federal side to say we have heightened pleading standards. We pled what we needed to plead in terms of these intentional torts. The intentional torts that related to not only Ms. Carden, my client, but also Mr. McGee, breach of contract, fiduciary duty, fraud. All of these at CR 333 through 347 are all well pled, but the court got ahead of itself in the trial court and simply looked at it, and they did something that 91A said you cannot do. 91A sub 6 says you can't weigh evidence. And there was no evidence to weigh anyway. There's pleading. All inferences are to be gained in favor of the petitioner, the plaintiff. That's what we did. But the court seemed to flip that standard and make a decision. Yes.
Is your position that the Peeler decision, the sole proximate cause bar in Peeler ought to be limited to legal malpractice claims and not to these intentional torts that you have pleaded?
Not only is that my argument, that's what this court's position is, Justice Bland, is that if you can plead and prove, if you can allege and prove, that's the important difference in the Pitts v. Rivas case that nobody had the advantage of knowing until just 9 months ago.
Right, but Peeler was a little bit different than Pitts, right? Because the malpractice in Peeler is similar to the malpractice alleged here, which is in connection with the representation of a criminal defendant. And I think Peeler's, causation pronouncement has more to do with the policy of if someone has been convicted and not otherwise exonerated or
Correct.
let out, reversed on appeal, that kind of thing, that public policy says we're not going to say that any malpractice was the cause because there's ineffective assistance of counsel and habeas and all these other paths to demonstrate,
Of course.
that the verdict, the conviction is infirm. So why should we extend Rivas to the criminal defense context?
Why you should extend Rivas not to the criminal defense context, to the fact that this is a 91A review that you are making. And this 91A review doesn't allow us to go and develop our facts. You should send us back to the trial court, remand this and say, wait a minute. Under Rivas, they should have an opportunity to put on the evidence to show that these intentional torts cannot be conflated into a negligent standard.
Well, Peeler says that it bars a claim for damages flowing from the conviction. Is your argument here that the damages for where you allege that the attorney was paid for specific services that were not rendered that those damages don't flow from the conviction, but they're sort of separate from the conviction, because regardless of whether he was convicted or exonerated, you still have these services that you paid for that you didn't get?
Justice Busby, here's the problem, is you don't have evidence to weigh that issue. And that's why.
I'm just asking what your position is.
Yes, that is our position, but you.
And I understand you've alleged that you paid for services that weren't rendered.
We did. We've alleged all of that. And that's why I think this final little sentence here that was written by Chief Justice Blackmun is so important here, where it says, if additional facts supporting additional claims are supported by the allegations, which we have done, but it also says, and evidence, then, very important word, then, the gravamen of the claim, because that's what you have to look at. What is the gravamen of our claim? What is the essence of our claim? The essence of our claim are intentional torts. It's not legal malpractice.
Are you saying that exoneration doesn't play any role in this?
No, I think exoneration does play a role, because I think there are some claims, honestly, that would not survive a Peeler challenge after we are able to put our evidence forward, particularly for Duncan McGee, but not for my client. Remember, my client, are both of them, and Ms. Carden.
Are you saying that, so part of this suit for fraud, et cetera, that you filed is going to be proof that the person was exonerated, didn't commit the crime?
No, ma'am. No. The fact is that he was convicted, and we are not challenging the fact that he was convicted. That's the important part of understanding what we're doing, what we're alleging. We're alleging intentional torts. We are not alleging negligence. And we are not attacking the conviction in any way, shape, or form. Remember, my client, Amber Carden, was never convicted of anything. She was never charged with anything. She was also the client of Mr. Carsey and Minton Bassett.
On that point, Rule 91A, you're right about the fact that it requires us to take as true the facts alleged
Correct.
in the petition. And that, there are facts, and then my question for you is, does the existence, you contend there's an attorney-client relationship?
Yes, we do.
With Carden.
Yes, we do, Justice
Yeah,
Hall.
right. So is that a fact, or is that something of a legal conclusion that doesn't get the same kind of deference on Rule 91A? Or is it a mix? And what have we said about that?
I think it is a fact issue that cannot be dispensed with a 91A. And I believe that's the court's position on this, taken, not only mentioned some in Revis v. Pitts, but in precedent leading up to Revis v. Pitts, because the key is that you can't take a fact issue and dispense with it at 91A. Not only is that a fact issue, but this question of, that we briefed fully, the question of being able to assert that there was a non-disclosure of information for over 4 years. We weren't able to get information from Minton Bassett for 4 years. And it was during that 4 years that part of the statute's limitations run. But the issue, there's a fact issue there as to whether we get tolling or not. You can't determine that through a 91A motion. That happens with the development of evidence leading to a summary judgment motion. This may come back in front of you for summary judgment.
What is the fact issue, though? How would you say there's a fact issue if there is no allegation of a written agreement about the legal representation, and she was not the person charged? How does she, just by supplying payment for legal services, become a client?
Because if you look at rule number 1.18 of the Texas Disciplinary Rules of Professional Conduct and Texas Rules of Evidence 503, you'll know that a person who consults about representation becomes a client. She consulted. Here's what she did. Carsey paid, or told her to pay him $300,000, and she paid it. She communicated, or he communicated with her about the case. He also and talked about plea negotiations. He talked about expert needs. He talked about bond issues. He shared confidential information with, you can't have it both ways.
So one of the allegations is undue delay and continuances of the trial.
Correct.
And your client said, this cost a lot of extra money. What if the criminal defendant thought any delay that keeps him free, before, in a case that was going to be difficult to win, was a good thing? And what if, so his instruction would be different? And that's the conflicting loyalty that might become apparent in your theory of client and client, and I'm just wondering what you think about that.
There are separate client issues here, for sure. And those client issues can be taken care of and developed with evidence. At the point that you return this to the trial court and say, look, you dismissed this too early. You didn't have the benefit of our knowledge in the Pitts v. Rivas case. You need to take this back and develop this evidence so that we have an opportunity to show you or the court and then potentially you that these facts, some apply to Ms. Carden, some apply to Mr. McGee differently. I see that I'm almost out of time.
Before you sit down, Counselor,
yes, Justice Sullivan.
Can you just tell us, whether it still is the record or not, what is the status of the CLD grievance against Mr. Carsey, Esquire?
The CLD, it's not in the record, the CLD grievance was dismissed. And I'm glad you raised it. May I go ahead and continue my answer? I'm out of time.
If you're answering that question, yes.
All right, thank you. As it relates to the Commission for Lawyer Discipline claims, we ran into a real difficulty because we tried to get evidence at the trial court and we were denied that. And
Denied by the trial court or denied by CLD?
By the trial court, because the CLD came and argued what we wanted was a copy of the transcript of the investigatory hearing, and the Commission for Lawyer Discipline wouldn't give it to us. They said it was all confidential. But the problem that raises...
What law, regulations, or precedent from this court is relevant to that issue? What governs that?
There's no precedent in it. There is a government code dealing with confidentiality.
Which section, please?
It's 2.16. I don't have a memory of the exact government code.
That's fine. You can send it to the clerk's office.
But here's the problem. What they've developed by their argument is to allow a lawyer to say one thing under oath to the CLD to save his license and protect that testimony from being used in a civil context, so that a lawyer can testify one way to save his license and another thing in his civil matter.
Okay, thank you.
I think that answers that
Thank you, Counsel. Any further questions?
I have just one last thing. Could you briefly talk about limitations?
About what, sir?
Limitations.
Limitations, yes, sir.
And I understand your 91A points, but it seems to me that, looking through your First Amendment petition, I just see the conclusory assertion that, well, it's a fiduciary relationship. I see a lot in your briefing that, gosh, we didn't get the file for 2 years.
4 years.
4 years, whatever it was. But I don't see a whole lot in here that looks to me as though you're saying anything that you needed that file for. So why is limitations not something that's gone as a matter of law?
Limitations is a fact-based issue that should be developed after this is returned to the trial court. So that's why I don't think it could be handled in a 91A context.
I guess that's my question. I think that 91A just automatically is all someone needs to do to survive 91A on limitations is just to say, well, it's been told and that's that.
That's right.
91A is
That's
done.
correct. That's correct.
All right.
Yep.
Thank you.
Thank you.
Thank you, Counsel. We'll hear from the respondent.
May it please the court, Ms. Brab will present argument for the respondents.
Good morning. May it please the court. My name is Elizabeth Brab, and I represent John Carsey and the law firm of Minton, Bassett, Flores Carsey, the respondents in this appeal. This lawsuit is an improperly fractured legal malpractice claim, even under Pitts v. Rivas, that was not available at the time of the third court's opinion.
So your position is that the mother was not a client.
Correct.
So how is it an improperly fractured legal malpractice claim as to her fraud claim?
As to her fraud claim? Because her fraud claim, it's the exact same facts and the exact same claims that are alleged by both Mr. McGee and his mother, Ms. Carden. And they all go, as this court decided in Pitts v. Ribas, the crux of the case is about the skill, diligence, and care that an attorney provides.
If there's
and
an
even the fraud
allegation,
claim-
excuse me, but if there's an allegation that services were paid for that were not provided, how does that involve any sort of, I mean, it's just a question of were the services provided or not? It doesn't involve any skill, or just a question of did you do it or not?
Respectfully, Your Honor, I would say it does involve skill, strategy. If you look at their exact...
What in the petition shows us that? Because we're limited to the face of the petition on 91A.
Yes, you're limited to the face of the petition, and yes, due deference is owed to the plaintiff's pleading, but still, common sense and common knowledge is available to be used, and a decision regarding what experts to be hired and whether they're retained and whether they're put on, it happens all the time, that experts are considered but then not hired, not put on as testifying witnesses. That's all
Are you saying it's
strategy.
impossible for a criminal defense lawyer to defraud his client?
I'm sorry, Your Honor, I didn't hear you.
Are you saying that it is impossible for a criminal defense lawyer to defraud his client in a way that is distinct from professional?
Oh, not at all, Your Honor. If you even look at one of the cases that petitioners have cited, it's the Goya case. And that is a pretty clear, so it's Goya Gagne v. Scott, 541 Southwest 3rd, 238. There, the complaint was not that counsel performed poorly or said, I may hire an expert and not, or we could retain an investigator, but we didn't. The contract between counsel and the attorney specifically stated that the attorney would conduct an investigation, file an application for writ of habeas corpus, and represent the client in court. The attorney took the money and did absolutely none of those things.
And that's the
what she's.
allegation here.
Sorry, go ahead, Justice Busby.
Isn't that the allegation here?
Respectfully, Your Honor, I would say no. He was represented. He received representation all the way through trial and sentencing.
So
and
as long as you do one thing, I'm trying to figure out the boundaries of this rule so that criminal defense lawyers aren't free to defraud people, which I think you agree is not, is not what should happen here, and that people shouldn't have any recourse if that happens. So what's the boundary of the rule? That as long as they do one thing, that's enough, and then it's all a legal malpractice claim?
I do believe, obviously, inaction versus inaction would be a very solid line. I think anything that arguably touches on an attorney's skill, knowledge, experience, their strategy. Strategy is part of the professional skill.
Is there at least a difference between the two petitioners and how they're situated? I mean, let's imagine that the $300,000 came from 1 million people who contributed on GoFundMe. May they all sue? Isn't this also a question of duty, and who the Court of Appeals sort of labeled it standing, but isn't this a question of duty and to whom the lawyer owed the duty in the first instance?
I 100% agree. And here we would argue that a fiduciary duty was owed to Mr. McGee. He's not the one that paid for counsel services. But Ms. Carden, well, she was the payor and a generous and concerned mother. She wasn't a client. She wasn't in a fiduciary relationship with this counsel.
That's what I'm kind of confused. Are you arguing that she is a client or is not a client?
She is not a client.
So then she has a fraud claim.
She could have a fraud claim in a different circumstance. I believe what she's bringing here is a legal malpractice claim.
There is a duty not to defraud people, right?
There is. Again, I would say that the claims she's bringing are actually legal malpractice. But
I
even if
understand.
they were fraud claims, yes.
Well, they
a
can't be
person-
legal malpractice claims if she's not a client.
Correct. So even if she was bringing a separate, not claiming to be a client, a separate fraud claim, I mean, in the end, her fraud claim is barred by the statute of limitations.
Well,
She brought it way
before
too
we
late.
turn to the statute of limitations, on page 17 of your merits brief, you say, "This is particularly true because Mr. Carsey specifically denies that any attorney-client relationship existed." And I guess whether there is a lot of daylight between Rule 91A and TWIC-ball, or a little bit of daylight or none, I guess my question about that assertion in your brief is, who cares? Who cares that you allege that there is not an attorney-client relationship?
I guess my point is, it's pretty evident from the pleadings, there was not an attorney-client.
No, but pretty evident from the proceedings. Again, whether we're talking TWIC-ball or Rule 91A, who cares that you allege, like, if the well-pleaded complaint, unless you're just telling us that's a pure, raw conclusion of law, not application of law to facts, who cares that the answer to the petition that's been filed here that we're supposed to take as true for purposes only of ruling on the Rule 91A motion to dismiss, who cares?
Then don't take our word for it and just go on the pleadings. Based on their pleadings, there's one conclusory statement that she retained Mr. Carsey as counsel.
Aren't there also well-pleaded allegations that she paid several six-figure retainers sequentially over time upon representations that we need to get an expert, we need to get an investigator, we need to get this and that? None of the things that, we're not fact finders here. We're not here to figure that out. That'll be 12 citizens good and true and a conscientious trial judge if we get there, but we won't get there. But my understanding at least was we have a Rule 91A now because the 12b-6 and Twombly and Iqbal and everything is, we don't figure that out now. So what is the thing, not the thing that is in Mr. Carden's answer, but what is the thing that is missing, the factual allegation that is missing from the petition here? So she said there was an attorney-client relationship, and there was money, and there were representations, and this guy represented, but then didn't do this thing. What if counsel opposite gets an opportunity to replead here? What thing would they need to have some Federal Rule 11 basis to allege as a fact that would then get them to an attorney-client relationship?
That there was any sort of representation or counsel provided to her for her specifically.
What about representations that if you remit funds, they will be used for a specific purpose? Is that a representation that's actionable? She relied on it when she wrote the check.
Yes, she was paying for complete representation for her son all the way through. And as part of those discussions, representations about, we're going to hire some experts or we need an investigator. But it was large blocks of funds that were transferred over to pay for the complete representation. And again, our argument is—
That sounds like things that could be developed when we have some evidence about what the money was used for or not used for. But I thought a representation was made to her, legal advice was given to her about whether to leave the bond in place or not. Isn't there an allegation of that?
But that's not affecting her legal rights. That's all a discussion of representation as to Mr. McGee,
Well,
not
it
as
was
to
her
her.
choice whether to leave the bond in place or not, right?
It would be her choice.
And she was given legal advice about whether to do that or not, is the allegation. So why is that not something, some basis in the petition that we could say, well, at least that's something that, some allegation of an attorney-client relationship because she's receiving legal advice for what she should be doing.
Regarding the bond, but all relating to, again, we would come back to it, it's all relating to Mr. McGee. If Ms. Carden had paid for nothing and was not involved, this lawsuit remains exactly the same On the other hand, if Mr. McGee was never arrested and charged with a crime, this lawsuit doesn't exist. Ms. Carden needs no legal representation. It is all based on Mr. McGee's arrest and incarceration.
But it's not really based on his conviction or incarceration, is it? I mean, if he had been acquitted, but they thought that they had been defrauded of money, would they not still have a claim?
Mr. McGee might have a claim that is not barred by Peeler, and Ms. Carden may have a claim.
If she paid these huge blocks of money, and yes, he was acquitted, but the money was purloined, misappropriated, whatever.
Right.
Would she not still have a claim even in the face of an acquittal?
She possibly could have, but limitations have expired at this point.
Well, I thought that's those totally different things. I mean, we're right now focused, I think, on the question of whether or not these are claims, and then I do want to talk about limitations.
Okay.
But we can't sort of mix and match.
Okay.
For it. So in terms of assuming there's no limitations problem,
Correct.
Why is this something that would be a Peeler problem? Because a conviction is not really an essential part of this at all.
Correct. It wouldn't be a Peeler issue if he'd been acquitted.
Why
Peeler
is it
arises because of...
Why is it a Peeler issue then because he's been convicted? Because that's really what I think in Peeler trying to get at is we're not going to let the convicted person benefit by going against their counsel. But if this is something that either way is just an independent, freestanding fraud, and if the mother pays this money and it's just sucked away for something, and that's the allegation, I don't see why conviction acquittal makes any difference, which is why I'm not sure why Peeler would make a difference for those claims. I mean, I think even your friend on the other side agrees there might be some that couldn't
Right.
survive Peeler, but all we need is one, right? Maybe
Yes,
it's the fiduciary
but-
duty, maybe it's the fraud, I don't know. But my point is, if it's something that escapes from Peeler because it's just a fraud claim that happens to have been committed by a criminal defense lawyer, it's all allegations at this point. Doesn't that get us past the issue that the Court of Appeals identified?
Again, I would say if it's a true fraud claim that isn't intermingled with some sort of skill, care, diligence, knowledge, experience of a legal professional. Every legal malpractice claim almost necessarily goes part and parcel with a claim of excessive
But the
fees.
fact that it could be, and that those are the things that you're saying, if it's intermingled, that just, my senses are, gosh, we're very premature in this case to say which category it's in. If it's a pure law point, yes. But if there is some factual aspect of this that's going to be dependent on what actually happened in this case and whether or not it really was intermingled, it's just not enough, is it, just to wave your hands? Well, it's so clear, yeah, it's criminal defense, there's all these things that happen and decisions that have to be made and strategy choices, so just don't worry about it. It's all covered under that. That just seems premature at the 91A stage to me. Where am I wrong? Tell me why I'm wrong as a legal matter.
As a legal, because there isn't the level of pleading of an allegation that to me goes to pure fraud. That is, I told you it would cost $100,000, that was the cap, it will cost no more, and then I charge you
Okay, so your
$200,000.
argument is that the First Amendment petition, no matter what discovery could reflect, it must inherently be something that is connected to the anti-fracturing principle. Is that your legal point? All right. I do want to hear your statute of limitations. Maybe this is a good chance for you to tell me why, assuming we disagree with you on that, nonetheless, limitations. Under 91A, there's nothing that can be shown in discovery that will allow for limitations to be told.
Correct. Okay, so the statute of limitations for a professional negligence claim is 2 years. The statute of limitations for fraud, breach of contract, breach of fiduciary duty, 4 years. Mr. McGee was convicted in 2016. The conviction and sentence were affirmed in 2017, and the underlying suit was filed in February of 2022. So almost 6 years after the verdict and more than 4 years after it was affirmed by the Court of Appeals.
So you've just told us that in order to know whether the fraud claim is independent or barred by Peeler, there needs to be a detailed examination of exactly what happened with the funds and was legal, was there some skill or judgment that was exercised, or was it just a question of the services weren't done that were represented that would be done? How would you know that without the files?
Well, I believe Ms. Carden's own words to this court In their reply on, I believe it's page 8, the exact quote is, Petitioner Carden actively participated in and directed the case strategy and decision-making. There's nothing mentioned here of all of the litany of complaints, putting Mr. McGee on the stand, different witnesses, the hiring of experts, the bringing in of a partner, a continuance that wasn't known at the time. And
But what you're
clearly-
saying, the level that they needed to know was to be able to parse out, like, payment by payment, exactly what this was used for, and, you know, did it involve skill or judgment, or was just something represented that was not done? And so how would she know how the money was spent without the files that you all wouldn't give her?
Yes, there was a delay in handing over the files. If you look at their pleadings on what their actual complaints are, all of that was known by the time the trial was over. There's nothing, and now that they have the file, as I think was mentioned by someone here, there is nothing specific tied to, we got the file, and this page of the file told us X, and that's why we're saying Y. There's nothing in their pleading that directly ties the discovery of the file to any of their claims. She marches through a list of various complaints. I was told it would cost $100,000 or more, and I ended up paying more. There was a continuance because Mr. Carsey had surgery.
But if the person is told, we need to hire an investigator, the investigator is going to cost $10,000. Okay, I write you a check for $60,000 or $100,000 or $300,000, whatever it was, in increments. Wouldn't that be enough? Because are you saying just because the exact amount wasn't paid of $10,000, $10,000 was assumed to have come out of that large amount to hire the investigator or the experts or whomever, right?
Correct. That would have come out of the total amount.
Right.
My point is, when we were talking about statute of limitations and where this would fall, like, do we need more? Her own words saying that she actively participated in and directed trial strategy and knew everything that's going on.
Does that negate the possibility, though, that even though she was involved in discussing with counsel that the things that counsel said to her were false and that she had no way, given the fiduciary standard here, and we do, I think, have at least some case law that says that when it comes to fiduciary relationships, it's more likely that tolling will be allowed because people are entitled to rely on things. So do those statements in the reply brief that you quoted negate the possibility that concealment occurred of a sort that would extend limitations, even though she was involved in discussing? I mean, maybe that was part of the concealment, arguably. I'm not saying that this survives summary judgment, but isn't it enough to survive 91A or not?
I don't believe it is. Based on, if you look at the totality of the complaints, everything was known at the time that the file was first requested. Everything was known at the time he was convicted, and then his conviction was affirmed. So nothing was learned from the file that's in their pleadings that says, aha, we saw this and we learned that. It is a discussion of, there was going to be an investigator, but they're well aware that an investigator didn't testify at trial. They were there the whole time during the trial. She was actively involved in the...
Did they know that an investigator wasn't hired?
I would say that her involvement and the fact that he was the person on trial would be aware, partly in her own statement saying that she actively participated in a directed trial strategy. If she was that involved, as she claims, she would know what was going on. She knows what witnesses were presented at trial.
Can you walk me through the breach of contract claim? In the operative petition, I guess it's like paragraphs 56 through 57. I don't understand, I guess, your view of why, A, she doesn't have standing, and B, this is barred. I mean, she's saying in these paragraphs that she and the defendants formed a contract and it included a duty for them to provide an accounting, and she gave them the money and they didn't give her the accounting that she was entitled to in the contract. I mean, that doesn't have anything to do with like legal strategy or judgment calls or representation. It just sounds like pretty vanilla breach of contract claim, doesn't it?
It does, and I would go back to that breach about receiving the file would have occurred in 2017 when she first asked for it.
Why
It's
does she
barred
not
by
have standing to
limitations.
pursue that claim?
Excuse me?
Why does she not have standing to pursue that claim? I thought you said on page like 15 or 16 of your brief she doesn't have standing.
I mean, our argument is that all of that relates to using the analysis from Pitts v. Rivas as well, is that what's the crux, what's the gravamen of this lawsuit? And it's a legal malpractice claim. And so that breach of contract rolls up under a legal malpractice claim, and because of that, she lacks standing there. Individually and separately, apart from that, would she have possibly had a breach of contract claim? Yes, but it's expired, it long expired.
But the Peeler, I don't understand what about her breach of contract claim would at all require her to challenge the fact of the conviction, right? She's just saying she didn't get the accounting she was entitled to, and whether he's guilty or not makes no difference to that claim.
Possibly.
I mean, that's the logic of Peeler, right, is we don't want people collaterally attacking the fact of a criminal conviction if you can't get it overturned through the normal process, because we have, ineffective assistance of counsel claims exactly for this reason. So go pursue it in habeas, and if you don't get it, then too bad. That was where your forum was at that point to pursue those kinds of legal malpractice claims is through habeas, get the conviction overturned, and then you can sue. But a claim that she didn't get an accounting doesn't have you can't present that in habeas. It doesn't have anything to do with the conviction.
Then possibly Peeler wouldn't bar her particular claim on that. Her claim is barred by statute of limitations, and then this is a fractured legal malpractice claim, so if everything lumps together, she doesn't have standing as a non-client. Thank you very much for your time.
Any further questions? Thank you, Ms. Brab.
I just want to add one thing. 8 years ago, I was at this court as a clerk for the Honorable Justice Johnson, and it was a privilege and an honor to be a clerk then, and it's a privilege and an honor to be back in front of you today.
Thank you, Ms. Brab. Mr. West, you have 5 minutes.
Thank you, Chief Justice Black. My learned counsel attempts to flip the burden and have a bright line
What
that
do
if
you-
ever
what do you-
legal
what
malpractice
do you
is
make-
involved, then it would be immune.
Excuse
I
me.
apologize.
What do
Ms.
you
Lynn.
make of your friend on the other side saying that there is not an attorney-client relationship here? What do you make of that with regard to the gravamen of this being a malpractice case?
This is, she has a client relationship with Mr. Carsey of her own. It was pled that way.
That's not my question. My question is, what do you make of the fact that they say, it seems to me that argument goes against them.
Yes.
Do you agree with that?
Yes, I agree. I think that they are trying to show that as long as there's a legal malpractice claim, every other claim creates immunity for a criminal defense lawyer, and that's just not the law. Pitts v. Rivas said that. All of the law building up to that. This is not about quality of representation. That's not what this claim is about.
And so for that reason, it doesn't really make much difference, does it, whether or not Mrs. Carden is a client? Because if it's not about the quality of representation, I don't see why the actual client wouldn't be able to bring the claims.
There's actually two actual clients, and that would be,
Well,
and I believe
the one
that-
who is the client in the criminal representation that's now in prison is clearly a client.
but he also has a claim for
And that's my point.
excessive fees.
So at least for some things, if, it seems like there's not a whole lot of power that's going to come by saying that his mother is also a client, because he would be able to bring some of these claims himself.
would be.
Whether she was a payor or not.
He would be, but.
And if for ones that he could not bring, I'm not sure legally that you can evade Peeler by just creating a magic escape hatch, saying, oh, all we need to do is have one more person sign on as a client, and therefore, and after that, they can go and pursue everything that Peeler would say that the criminal defendant cannot pursue. That can't be right.
No, it's not, and that's not the
So what
rule.
difference does it make whether she's a client or not?
It makes a difference because she has a claim, and because the defendant here violated their duty to her of confidentiality, of of breaching their fiduciary duties with her.
So a
This-
fiduciary duty claim would.
I'm sorry.
It's me,
explain.
I'm sorry. A breach of fiduciary duty claim would connote an attorney-client relationship,
Absolutely.
right? Okay.
Yes, it would, and we pled that breach of fiduciary duty claim. If you look.
And while I have you, we have said that affirmative defenses can be raised at the Rule 91A stage. And I'm just wondering about limitations in particular and what would make it unsuitable as to be raised at the Rule 91 stage. And if it's not unsuitable, why it would be unsuitable in this case?
I think it's unsuitable because it requires fact determination, and you can't do that at the 91A stage. You remember, this 91A is only, 15 years old? I think it was 2013 that it came about. And we haven't had a lot of law under 91A, but 91A, when it was drafted, looked to be somewhat like a 12b6 motion on the federal side. But we have different pleading standards in the state, and you all have referenced that several times, that we have notice pleadings here, and that's what we did, because remember, Peeler is limited to malpractice cases and the conviction of a criminal. Ms. Carden was not charged with anything. She wasn't a criminal. She, under 1.18, 1.05, 1.08 of the Disciplinary Rules of Professional Conduct, clearly make her a client. Plus, remember, Texas Rules of Evidence 503, you approach a lawyer with the view of representation, you have a client. A lot of lawyers don't know that. But once that happens, you have a client, and there are duties that flow from that attorney-client
There could be an awful
relationship.
lot of conflicts. Probably a lot of lawyers have clients they don't realize that they have, because it's pretty common for parents to pay for their children's defense and talk to the lawyers and try to help. That's a normal thing for a parent to do. And you're saying in all of those instances, the parent's the client?
Can be, and it's
Wouldn't we
very
expect
dangerous.
there to be something that would be more expressed than that? Because you can get into tough situations, can't you, as a lawyer, if you got this parent who's a client who wants to do one thing, and then you have the child who's the defendant wants to do something else, or maybe the lawyer thinks it's in his interest, they have to withdraw at that point.
Justice Young, you're exactly right. And an attorney has to be very, very cautious in those situations and draw distinct lines, maybe even get other representation for that parent.
And yet, it seems like it's probably a very common thing for parents to do the thing that's happened here, and I think that probably a lot of lawyers don't believe that creates a different and distinct client relationship. So one possibility is that you're right, and that all along people have been doing it wrong, and we've got all these latent nation conflicts that are serious problems, and we're going to have the CLD have an awful lot more work to do than they think. Another possibility is that doesn't actually create a client relationship. We need something more express, something more clear to do that. And I'm not sure what difference it makes for your case. You can win either way, can't you?
I can win either way, but it is a factual distinction that needs to be developed through the discovery process, that potentially they may be able to bring a motion for summary judgment and say, I didn't do that. But at the pleading stage, at the 91A stage, they don't get to do that. And if you look at our fraud pleadings, for instance, from Ms. Carden.
So Chief, Mr. West?
Yes.
Further questions?
Yeah, just
I
one,
apologize. Thank you.
just
Justice Sullivan.
one more. This could be irrelevant, but does the record reflect the facts or nature of the crime for which the mother's son was committed?
I don't believe so.
Well, as to that, and also as to the CLD question that I asked you at topside, speaking only for bar number 8, I would find any post-sub briefs helpful.
That is.
Thank you. That's, yeah.
There is a record site there, and I.
Post-sub, I would personally find helpful. Thank you.
Yes, sir. Yes, sir. There is. Yes. Thank you.
Any further questions?
I have no
Thank-
further questions.
Thank you, Mr.
That
West.
doesn't matter at all.
Thank you,
Thank you,
Mr. West.
John.
Thank you to all counsel. The case is submitted, and the court will take a brief recess.
All rise.